Good morning, our viewers, community of Northern Cape, our colleagues out there in each and every province, colleagues of DOJ, NPA. My name is Tina Mpaka. I'm a senior maintenance prosecutor, newly appointed in the NPA here in the Northern Cape Division in Kimberley, based in Kimberley at the DPP. I'm responsible for the training of maintenance officers, maintenance investigators, and all other prosecutors in the province. I'll also be responsible for all the complaints that come through here in the DPP through representations or in any manner that comes through our DOJ offices. Well, today it's our maintenance webinar that is being followed from last year, 19 September 2026. It is a follow-up. This webinar of maintenance was introduced by National Prosecuting Authority, which is our organization, that making sure that we as NPA make sure that all the community and all the officials are educated about maintenance. I'm not here alone today. We have our presenters, Mr. Mulaudi, which is a senior advocate in the DPP's office, and also Mr. Matuka, our legal administrative officer in the DOJ. They will be our speakers today, and I'll be your host and moderator. I'll let them introduce themselves.
Thank you very much, Ms. Mpaka. Good morning to our viewers. Good morning to our colleagues within the NPA family, within the criminal justice system. My name is Moketsi Mulaudi, the Senior State Advocate, Provincial Manager of a unit called Sexual Offences and Community Affairs Unit within the NPA. I'm responsible for a unit that is entrusted with the responsibility of ensuring that the gender-based violence mandate of the NPA is realized. I'm responsible for 5 components within SOCA. I'm responsible for maintenance. I'm responsible for domestic violence. I'm responsible for sexual offenses. I'm responsible for trafficking. And I'm also responsible for the management of the Tutuzela care centers in our province. This is the second segment of our webinar, which was arranged by the National Prosecuting Authority, where we plan to have an integrated approach for our key stakeholders like the Department of Justice to ensure that at the end of the day we have a system that is smooth in the best interest of our children. Thank you very much.
Good morning, colleagues, our viewers there at home. My name is Jack Matuka. I'm the Deputy Director of Legal Administration and Advocacy. And part of my responsibilities includes the smooth running of the family courts, which will include your maintenance. And our unit is also responsible for the management of children in conflict with the law. That is your child justice, your women trafficking, the equality courts, the LGBTIQ+ sector. And for the purpose of today, we are only going to engage on maintenance. Thank you.
Our viewers, welcome again. Today in the maintenance, we're going to learn about the process of maintenance. Firstly, what is maintenance? The role of our officers in the maintenance section, and where you can go if you want to apply for maintenance. We are in relation with the DOJ and NPA officers. I'll start with Mr. Mulaudi. Mulaudi will start to tell us what is actually maintenance, as this is the objective of our webinars.
Thank you very much. I think during our first segment, we articulated on what is maintenance, but I think it's important that we have to refresh our viewers in relation to what is maintenance. But it's very important to articulate where we are in terms of maintenance because it's an evolving component of our mandate. It's evolving in a sense that we need to go back and say, what regulatory framework do we have in terms of maintenance in the country? Is this regulatory framework effective to deal with maintenance challenges that we are facing? I think we have to go back and say, our constitution put the best interest of the child at the center of our activities. In terms of Section 28(2) of the Constitution, we need to ensure that the best interests of the child are realized. And secondly, in terms of our Children's Act, the best interest of the child is catered for. In terms of domestic violence, we do have what we call emergency monetary relief in terms of maintenance. We further go to our prescript, our regulations, and also our national strategic plan when it comes to GBV. A person will ask as to why maintenance is regarded as a GBV, precisely because of the fact that we are quite aware in the country that maintenance features squarely in the national strategic framework of GBV in this country, Pillar 5. And trust us to ensure that at the end of the day, we must create a system that is going to ensure that we've got economic power for our vulnerable groups. So definitely, we have to deal with maintenance in that context that this is a GBV, and this comes at the backdrop of the recently where the president indicated that actually classified GBV as a national disaster. So it's very important that as we move along in the criminal justice system, we must ensure that we have that system that creates that. We also have a regulatory framework in terms of our national, our international covenants that South Africa is a signatory to that, because at the end of the day, as we move along with maintenance, we must ensure that we also stick to the international prescripts that we have to conform to. And then in terms of our regulation, working with the Department of Justice, we want to create a smooth system for the vulnerable groups and ensure that at the end of the day, this system is realized and our people get access to justice. Let's start with what is maintenance. And before we can even talk about maintenance, I think it's very important that we have to articulate the myth that we have in this country in relation to maintenance. I want to start by demystifying this myth. The first one, it's about the system itself. There is a myth that this system is designed for women against men. We do want to encourage our men, and we know very well very responsible, but they can't access this system because of the myth that we have, and also because of the stereotypes that we have in relation to maintenance. We encourage them to access this system. This system is designed for South Africans, and this system must be accessible to South Africans who need the system. And secondly, there is another myth that maintenance stops at 18. It does not stop at 18. The law says until the person to be maintained is self-supporting. Some people will say self-sufficient, self-supportive, but the law says self-supporting. And thirdly, it's in relation to what is happening in our courts. There is a myth that maintenance officials in courts change the paternity results that are coming from the labs. The courts are not responsible for conducting paternity testing. They cannot change that. So that myth must be dispelled. And one of the things that we want to encourage our communities to do is to partner with us in the maintenance system and ensure that at the end of the day, this myth are realized, because we also advise our maintenance officers to have this maintenance fora where maintenance challenges are discussed with the communities, with the beneficiaries, to ensure that people understand. Because remember, as we roll out this awareness campaign, we are basically preventing the misunderstanding when it comes to the. And the last myth that I think it's very important for us to talk about is the fact that the criminal justice system is against all men in the country. This maintenance system must be accessed by all. Thank you very much. I want to talk about what is maintenance. When you go to the definition of maintenance, it talks about the upkeep of a person. Meaning we talk about accommodation, food, we talk about clothing, we talk about medical expenses, we talk about educational fees. But when you look into our form of application of maintenance, it covers a variety of issues. It covers the upkeep of the hair, it covers a lot of things. That's why it's important that when we go to those courts, there should be understanding from our officials that they should be able to assist our maintenance beneficiaries to ensure that they understand this application form, and going forward, they'll be able to partner with us as we go along in the maintenance inquiry and up until the order is made. So maintenance is the upkeep. It involves a lot of things, but our application form is more comprehensive to deal and cover with all the aspects that relates to maintenance.
Thank you, Tate Molaudi, for explaining in depth about maintenance and the framework of maintenance. I'm happy today, the viewers today, because the speakers are men and I'm a female. And Mr. Molaudi has already discussed the myths that is on the maintenance. Normally, when you go to court and then find a woman as a maintenance officer, uh, mm, probably because most of the people who comes to maintenance are men, and then they would think that no, because you are a female and then you siding with the females. That's not how it works. And then I happy that also Mr. Mulaudi has discussed that, and then he's also responsible for maintenance, and then he's worked with maintenance, and you can see, when you look at him, that he's a very responsible parent and a male. So our viewers, let's all be responsible. Maintenance is not only about men supporting the children. Also, women, we are responsible for supporting our children. And our viewers, there will be also questions that will be coming from the floor and also outside. Feel free if you have a question, just if you're on a laptop or a cell phone, just type your question, and we have all the senior maintenance prosecutors in all the provinces who have been viewed now and are on the platform will be able to answer your questions. Thank you. Now that Mr. Mlaudi, you've covered the maintenance, if a person want to apply for maintenance, where does the person go and what are the requirements, and who can apply for maintenance, so that the viewers can know that if I want to claim maintenance for my child, where do I go?
Thank you very much, moderator. We must start indicating as to what is the legal duty. Before a person make an application before any court, there should be a legal duty to maintain. Meaning, if I'm called upon at the maintenance court for a maintenance matter, there should be a legal duty to maintain that particular person. And where does this legal duty start? It starts from the relationship. A father, daughter, son, meaning a child and a parent. Siblings, they can claim maintenance against each other. Legally adopted, they can claim maintenance against each other. You can imagine if, let's say, for instance, this legal duty is extended to the aunts and uncles and nephews. You could imagine how much this system is going to be clogged with those applications. Because if I have 17 uncles and aunts, obviously, there can be challenges in terms of they are allowed to make that application. However, that legal duty does not extend to that. meaning it is limited to children, parents, grandchildren, grandparents. And one thing that I want to make it clear to our viewers that our Maintenance Act, we are going to unpack it, but I don't want us to go deep into the act because this is a webinar. Maintain at all because it only catered for entertain the the divorce. And one thing that we have to also consider the relationship, and then the second one is the issue of the needs. There should be needs, and obviously those needs are going to be articulated on the type of documents that we are going to articulate. And the third requirement, it will be the means of the person to maintain. And the means does not necessarily mean salary. That's why you find people who are not even gainfully employed. They are called upon to ensure that they maintain because it does not mean that you must be salaried for you to pay maintenance. So those requirements are key. And also, I think as a follow-up as to the jurisdiction of that, because there should be a jurisdiction. And jurisdiction is going to be determined by the papers that, by the documents that you are going to articulate. Jurisdiction is the power of the court to entertain the matter. So when it comes to maintenance, and I want us to go back to before the amendment of this Maintenance Act in 2015. We're following the complainant, we're following to where the child resides. But during the 2015 amendments, we now follow where the complainant resides, where the child resides, and where the complainant carries business. I'm going to give you an example. If the complainant is working in Kimberley, but the complainant is originally from Bloemfontein, and the child stays in Bloemfontein with the mother of the complainant works in Kimberley. The complainant now is allowed to make an application in Kimberley court because of the fact that it's going to be easy for the complainant to have access to court because we are talking about accessibility to court. So this is what this legislation made it easy for the complainants for them to make an application in this court where they carry business, meaning where they work. So we are not confined to this physical proximity to say that, no, you can't make an application where you work because you are not staying there, you stay in Bloemfontein. Very important that this legislation has evolved and we as the maintenance functionaries, we just ensure that those amendments are effectively applied. And in terms of the application itself, there are requirements in terms of the documents that we require in an application. The application process entailed the submission of documents that will also assist the maintenance officer to determine jurisdiction to entertain this matter. We will definitely require the birth certificate of the child. We will require the ID copy of the complainant. We will require the proof of address because eventually there's going to be a maintenance inquiry. We'll require a bank statement of the complainant. We'll require various documents from the complainants to ensure that when we have this inquiry, after now the respondent has been called, all the documents are necessary. So it's very important that as we go out to our communities, we have to ensure that we capacitate them in terms of the documents that are required in terms of maintenance application.
Thank you, Mr. Mulaudi, for your clarification. But I just have one question. I heard you saying, or you talking about grandchildren and grandparents who can claim maintenance. Does it mean that the grandparent can claim maintenance from the grandchild, and also the grandchild can claim maintenance from the grandparents?
Yeah, let me take it back. As I indicated, the 1963 Act basically spoke about the issue of maternal grandparents being responsible for maintenance. The Maintenance Act that we are currently utilizing as amended, Maintenance Act 99 of 1998 as amended, caters for the grandparents maintaining both grandparent, meaning paternal and maternal, being responsible for that. But in the maintenance setup, we don't necessarily straightly go to the grandparents. We need to exhaust the part where we say investigation must be done, where we can conclusively say that the father of the child does not have any income, any source of income to maintain this child. And then when we call the grandparents, we call both maternal and paternal grandparents for maintenance, if there is an application. So that process makes it easy now for the issue of saying that no, only maternal must be responsible. So both grandparents are responsible for that and vice versa.
Thank you, viewers. I think that has been clarified. You heard that. It means that if a grandparent can support the grandchild, then it means vice versa. Then the grandchild can also support the grandparent, meaning that the grandchild can also claim maintenance from his or her grandparent. Also, the grandparent can also claim maintenance from the grandchild. It does not mean that when your grandparent support you, then now you are educated and then you are far with education and then you are employed. Now Gogo is suffering there alone at home. It does not mean that you cannot support your grandparent. Then it means that maintenance can be forwarded, a claim can be forwarded to our maintenance office, and you can be liable to support your grandparent. Thank you. And coming to Mr. Matuka, we heard that maintenance can be applied for, and also there are requirements that are needed in the maintenance office when you go and apply for maintenance. I just want to know where do you take this application and what is the role of the Department of Justice in the maintenance system?
Thank you very much, Mampaka, and the viewers there at home. Let me start by commenting on the first questions that you raised to Advocate Molaudi. Number one, there's a misconception when it comes to the age determination, when it comes to maintenance. Most people are confusing child justice with maintenance. When it comes to child justice, we are saying a child is no longer a child after turning 18. That is child justice when it comes to the conflict of management of conflict of children conflict with the law. It ends at 18. But when it comes to maintenance, we are saying when the child is self-supporting. Now, remember, we've got access to internet and all these legislations around the world. South Africa does not have age determination when it comes to maintenance. But our neighboring country, when you go to Namibian Maintenance Act, it will tell you that the child to 18 is done. You cannot apply for maintenance if you attain the age of 18. Go to Tanzanian Act as well. They are very clear when it comes to the age determination, when it comes to application of maintenance. But in South Africa, unfortunately, we don't have age determination. And secondly, I would like to comment to our viewers to say, even if you know that you are responsible to pay for maintenance, but as soon as you are made aware that the child is employed somewhere or is having an income one way or the other, go and apply for a discharge at the court. Don't just sit because you are waiting for a court to tell you that the child is self-supportive. You have to make means to bring the information to the court. Secondly, when it comes to the issue of grandparents having to support grandchildren, Advocate Malaudi indicated the fact that there's also a means test that is applicable. Does not come automatic because I'm a grandfather, I must now support the grandchild. If I'm, for instance, I'm on pension, I'm receiving SASSA grant. SASSA grant, I won't be able to survive for the whole month with that money. Much as the child has got the right to apply, but the means that child won't be able to qualify because of the means test. And then when it comes to the issue of where do you apply for maintenance, in the Northern Cape, we've got 38 courts. That means each and every area or district is covered when it comes to the application of maintenance. And in all those all those courts, we've got trained clerks. That is a starting point where you go and apply. And then after taking the application is going to be taken to the maintenance officer, who's going to decide whether there is a maintenance case in this matter or there must be inquiry to be done before we take the matter to court. But by virtue of our limited number of maintenance officers, we go back and rely to the Act. The Maintenance Act make provision for all prosecutors stationed at district court to be deemed as maintenance officers. Currently, we are only having 8 maintenance officers in the region, which makes it very difficult for us to be able to reach everyone. But we are also relying on NPA to assist with prosecutors. In other words, there won't be a client that will be turned back to say there's no maintenance officer, because all the courts, they have prosecutors. I think I've covered the first part of your question.
Yes, thank you, Mr. Matuka. So it means that when you go to the maintenance courts, you'll have all the assistants, whether the maintenance officer is there, whether there's no maintenance officer is appointed, then the prosecutors will assist. Um, Mr. Mulaudi, Mr. Matuka just talked about the prosecutors in the maintenance courts. Can you also elaborate on how do the people can get assistance in regard with the prosecutors?
Thank you very much, moderator. One of the things that we need to make sure that our viewers understand. Mr. Matuka indicated the fact that we don't have enough maintenance. I think in the province we only have 8 or so. And then we've got, yes, investigators are enough, but we do have 8. You can imagine if 8 courts have maintenance officers appointed by the Department of Justice doing that maintenance matters, what was going to happen if prosecutors were not there? So it means 30 courts are run by our prosecutors from NPA. And this does not come because of an arrangement that prosecutors must do maintenance matters. When you look in terms of Section 41A of the Maintenance Act that we are currently utilizing as amended, prosecutors are deemed maintenance officers of the respective courts. Meaning in this province, 30 courts, maintenance matters are done by our maintenance office, our prosecutors. And we appreciate that as the Sexual Offences and Community Affairs Unit, that our prosecutors are on board. We train them on a yearly basis. We ensure that our prosecutors are trained on maintenance developments, because this is an evolving topic which needs you now and then to be trained on various aspects, because that's judgments that are coming from courts that prosecutors must be made aware of. So prosecutors will continue to assist in this, not to assist, to do maintenance matters as required in terms of the law in this province.
Thank you, Mr. Mulaudi. I see now that I also have a duty and responsibility to fill up these big shoes that you have left for me, to train the prosecutors and the maintenance officers so that they can be put up with maintenance and also have the tools to help our communities here in Northern Cape. Thank you very much. Mr. Matuka, when an application has been done and a client wants to be assisted, who will assist them in court?
As indicated, the point of entry is our maintenance clerks, and they are stationed at all the 38 courts. And the next step would be the maintenance officer or the public prosecutor for further assistance. Yes.
Thank you. Mr. Mulaudi, Can you also tell us about the process of maintenance? Now that you've dealt with the requirements on who can apply for maintenance, that the father can also apply for maintenance, the mother can also apply for the maintenance, also the child who is above age of 18 can also apply for the maintenance, and the documents that are required to go to the maintenance court. Can you tell us about the process when a person has gone through this process of getting all those documents and getting them to court? Now, what is the process? What happens in the maintenance court? And also, can you also clarify on what are these documents that are needed in court?
Maybe if Advocate Mulari can address that question. Much as I've indicated that we don't have age determination when it comes to maintenance in South Africa. But once a child attains 18, if there's an application for increase, we are going to tell the applicant, who in most cases is the mother, to say the child must now come and bring the application as an adult. That we call substitution now. That means the order still is valid, but now we are just going to change the name of the parties because the child is now an adult.
Mm-hmm.
Thank you very much. I think I must go back to the objectives of our Maintenance Act. Our Maintenance Act entrusted us to ensure that we've got a smooth, caring, and effective maintenance system in our country, which basically talks to the Constitution now in terms of access to our courts. And it's very important that as complainants approach the court, there is an easy system for the complainants to follow in terms of the application process and in terms of how these matters are adjudicated in court as well. The application will come in by the applicant to the maintenance clerk. All the necessary documents will be there in terms of opening the file. The file will be opened with the necessary documents that are indicated. And the matter will go now to the maintenance. This is how the process should go. Should go to the maintenance officer, prosecutor, or justice appointed officials in terms of 41A, 41B, because prosecutors is 41A. Because the maintenance officers are legally qualified, in as much as prosecutors are legally qualified. Those maintenance officers appointed by the Department of Justice are legally qualified. This is one way to ensure that as our people approaches the court, we've got legally qualified people to assist them in court. Now, the maintenance officer must now decide, because it will go like a normal decision docket when you would deal with the criminal court. The prosecutor, the maintenance officer or the prosecutor, maintenance officer in brackets, will ensure that, will decide as to whether am I going to institute an inquiry? Is there jurisdiction? All those preliminary issues must be resolved at that level. That I've got jurisdiction, I can entertain this matter. I've got all the necessary documentation. I can now institute an inquiry. But before you can even get there, how are you going to bring the respondent in this court that we are going to entertain this matter? What we normally do, we start with the regulation. Because remember, he said section 6, where now we have to investigate, meaning it gives you an opportunity as a maintenance officer now that you must get your ducks on the row in terms of all the necessary documentation that are required to institute this inquiry. So that regulation will give you that platform to investigate further if you have to do that through the assistance of the maintenance investigator at that point. So the application will be entertained. If the maintenance officer says, yes, I'm going to institute an inquiry, decide that I'm going to institute an inquiry, obviously regulation must kick in now to bring the respondent before the court, all the parties before the court, if there are other parties that must come to. And the maintenance officer will have an inquiry. If the maintenance officer decides to institute an inquiry, we'll have an inquiry with the parties, entertain this application, go through all the necessary documentation that I spoke to, and at that level, there can be an order, either an interim order where some of the information maybe is not adequate to address some issues that the maintenance officer raised, or the parties can finalize that matter at that stage with an order to say that we agree the maintenance is going to be 3,000 for this child and there's going to be medical aid. At that level, it provides you with an opportunity as a maintenance officer to deal with all these issues that you want to deal with as you prepare, maybe if they don't agree, that you are going to hold Section 10 inquiry now in court. But there is one thing that I want to, and I talk to it when I deal with the misconception when it comes to paternities, because paternities can be resolved at that level. The respondent will come and say that I don't have a problem, but I don't have a problem with maintenance, as you say, but my issue is paternity. I don't believe that this is my child. Right there, paternities must be resolved. Meaning, this matter must now be referred for paternity to be conducted. And we are not doing paternity testing, as I said in our court. This matter will be referred to the laboratory, where parties will be given a date and time to go to the paternities. And then from the court perspective, we only receive the outcomes. That's why I said from the beginning, there's no way in which the maintenance functionaries can change the outcomes of the paternities. And one of the things that I want to raise is sometimes we get instances where the respondent is gonna say that despite the fact that I'm working, I cannot afford paternities. I'm going to request the maintenance officer to make an application on my behalf that the government must pay for these paternities to be conducted. It is not given. There should be an application. The court will have a mini inquiry to determine as to whether the government must pay. Because remember, we don't have that ring-fenced amount where we say that we cater for paternities in our country. We don't have that enough money to do that. So there should be a mini inquiry. The magistrate must decide as to whether the government must pay for these paternities or not. That's a determination that must be done by the court. And there must be an application from the maintenance officer that the respondent requests that the government pay this. So the magistrate will take the respondent through the process in terms of determining the income of the respondent as to why the respondent is not paying the sum. Bagaetsho ke rata go tsibusa batho ba rona ba Northern Cape. Re na le bothata. And I'll speak to this when we get to the challenges. We must not abuse the system that is designed to assist us when it comes to paternities. Still on that point, you get instances where the complainant will bring 5, 6 people as alleged fathers in the maintenance court. And we also impress on our maintenance officers to keep check on those because it has to do with expenses. To issue this document, it's money that we're actually losing as the government. So we need to ensure that as we go out and educate our public, our communities, we ensure that we talk to these issues, that this system was designed to assist the vulnerable groups. Let the vulnerable groups not abuse the system that is designed to assist them. We'll talk to it when we deal with challenges. Now the issue of paternity will be dealt with. They'll be given a return date. They'll come to court. The result will now be, there'll be a document that the outcome of the results are going to be sent to the maintenance officer. The maintenance officer will read the results to the parties and also will give them the copies of their results if they were referred by the court, of course. And then if the alleged father is now confirmed that now is the father, obviously we are going to continue with the inquiry. If it's not, that's where everything stopped in terms of the legal duty. Because remember now, we don't have a legal duty to continue with this inquiry going forward. And now, during that particular process, the role of the maintenance investigator is very important. And I must emphasize that the maintenance officer, the maintenance prosecutor, does not represent either of the parties. It must be made clear. The maintenance officer does not represent the applicant, does not represent the complainant. The maintenance officer, the maintenance prosecutor in that inquiry represent the best interest of the child as enshrined in our constitution and in our other legislation, including this Maintenance Act. So we need to ensure that we deal with the issue of unfairness that is unnecessary in our maintenance system. To think that the maintenance prosecutor, the prosecutor or the maintenance officer represent either of the parties. That's why legal representation is catered for in these proceedings. Anything?
I'm happy that you've explained everything, and also you touched at paternity. And also the abuse and the challenge that is faced in the maintenance courts in the Northern Province about the abuse of coming to the maintenance office. I just want to ask something, Mr. Mlaudi. How does you deal with the question wherein the order was granted and now the person who's supposed to be paying maintenance comes to court and say, we went for paternity, I've been paying maintenance for about 10 years, and then this is not my child. What happens with the money? Can he or she claim the money back from the person who was paying maintenance, or how do you deal with it as Justice Department and NPA?
Oh, before you can even get to that, let me just finalize on the application process. So that issue is dealt with. The paternities did not confirm that it's the father. Obviously, it ends there, and then it continues now, where now the alleged father now is confirmed to say that this is your child, and then the inquiry will continue at that level. If the parties agree during that stage, where they say that no, maintenance can be granted, we don't have a problem, the maintenance officer will continue with it going forward. But now, if the parties does not agree at that point, and all the necessary information is there for the maintenance investigator now to institute an inquiry in court now, meaning in terms of Section 10 of the Maintenance Act, obviously the parties will now be given an opportunity now to go to court now, just to ventilate these issues going forward. So now we dealt with the regulation part, because remember we said it gives you an opportunity for investigation. We have all your ducks on the row now. You prepare this matter to go to court, because the parties are now not agreeing on the amount, the quantum itself. And one of the things that we normally do is we issue now the parties now with the subpoenas now to appear for this inquiry, this Section 10 inquiry, where the matter will now be dealt with in court now, where evidence is going to be led. And if the parties are represented, obviously they're going to be led by their respective attorney. But we don't undermine the role of the maintenance officer during those stages of trial, because the role of the maintenance officer is key, because at the end of the day, the maintenance officer represents the best interest of the child. As I said, it's not representing either of the parties. So the maintenance officer will play an active role. As we train prosecutors, we normally say that you are not going to leave anything in the hands of the court. What if the court does not have hands? It's important that our maintenance officers, our prosecutors play an active role during these formal inquiries, because of that's where now issues are now going to be dealt with in terms of the ransom sent. So their role is very critical. And besides the fact that the parties are represented, they have a bigger role to play to ensure that they assist the court to arrive at the decision that maintenance must be paid. Now, the issue of paternity became in this province. I'm going to confine myself to this province, because we dealt with a lot of paternity disputes that are unnecessary. And it boils down to the issue of awareness, because remember, awareness is a form of prevention. The more our communities are informed into the court as to how the court process unfolds in court and what kind of application do we have in court, the more they'll be able to be more careful when we deal with these issues of paternity. Unfortunately, our law does not cater, the Maintenance Act does not cater that now that you are not the father, you are confirmed that you are not the father. Unfortunately, we cannot assist you in the maintenance court to say that, can the complainant pay you back? We can't do that as a maintenance court. We must, at the end of the day, ensure that our communities are well equipped in terms of awareness campaigns to ensure that as we go along in implementing the Maintenance Act, integratedly with our communities, they understand the realities that they were dealing with in those courts. That we encourage our complainants, and it's not even limited to females, as I said, our complainants to ensure that when you bring a person before the court, is the person who has a legal duty to maintain. Not bring the other one. The next time you bring the other one, these are things that we are not going to, because the system is not going to cater for such things going forward. We need to ensure that we educate our communities doing that. Unfortunately, Ms. Mpaka, we cannot assist you that. If you have a private attorney, you go the civil route, you do what we have to do. From the maintenance side, unfortunately, we cannot, as the system, assist you going forward.
Maybe just to add, you've got different types of court orders. The most common one is your consent order. Now that you've consented that you are going to pay 500 for this child, you cannot come back to the maintenance court after 10 years to say, hey, I've given this consent. The agreement between you and the mother. But in most cases, people that will court is people that cannot afford to maintain the child. Now you'll have proof you've been paying this money for 20 years, but it's unable to pay you back. That means you are fighting a losing battle at the end of the day. And was engaged attorneys that you are going to pop out money to pay for them. At the end of the day, the person cannot afford to pay you back. Now there is this. Remember, we said you don't only need to have a salary so that the court can held you liable to maintain. Whatever kind of means or income is acceptable to the court. Now there is this Greek word, the saltire. That means it's a salary in normal language that we use. We normally say man. Saltire refers to salt in Greek. Man brings taste in the house. And that taste comes with children born out of that family. And you must take responsibility for the change, the taste that you have brought. I'm sure you can hear me. Thank you.
Thank you very much. I just want to touch on the issue of paternities now, as the parting shot. That's why I'm saying from the beginning that the issue of paternities must be resolved there, that level. Because at the end of the day, it does not mean that you can't raise the issue of paternity. It needs to be raised at some point. There are instances where you've been maintaining for some time. After some time now, you realize that no, but there's something that I'm doubtful for. I'm doubtful. And then I need to resolve it. As Mr. Matuga indicated, it does not actually, it does not make it difficult for you to raise that issue at any level. Because remember, sometimes you are going to maintain for a longer period of time, is you are not precluded that you cannot raise an issue of paternity at any time. That's why sometimes when you prosecute, you'll find that the issue of paternity will come at a later stage when the person is now charged for failure to pay maintenance. Now the issue of paternity comes in. You are allowed to raise that issue of paternity. And at the end of the day, it boils down to what I started from the beginning to say, that we need to resolve the issue of paternity. It's very important that it must be resolved at that level. If you have issues, raise them there so as we can resolve the issue of paternity, then we move along. That's why the maintenance officers ask you from the beginning to say that, are you okay with the issue of paternity? Are you sure that this is your child? Do you have any issue that you are going to raise in paternity? In other courts, there are specific forms that you utilize where you say that you are now confirmed that you are the father of this child. The issue of paternity is dealt with. We are okay with that aspect, that now we know that we've got the right person before the court. This person has a legal duty to do that because we agreed from the beginning that this is my child. But it does not preclude you to raise it at some point to say that, no, I've got doubts. Very important that, again, now to go back to what I said from the beginning, that our people, our communities must ensure that we bring the right people before the system.
Thank you, Tate Mlaudi. Our viewers, you heard that. Um, that means we all have to be responsible. We must be responsible adults, responsible parents. When you enter into a relationship, no multiple relationships, and then engage in sexual intercourse, and then therefore when you go to the maintenance, and then you get problems. Now, Tate Matuka, can you please clarify the roles of maintenance investigators in the maintenance matters? Now you've got this document. Let's say a person wants to claim for maintenance, but he or she says, "I don't know the whereabouts of the person." How are the maintenance investigators going to assist in this situation?
Thank you, Ms. Mpaka. Normally when you do advocacy or community outreach programs, we always advise women before you put your pens down, get to know the person to make life easy for us in the court. You can't say that I met this guy, said this Jack. We met at the shaving last night. I don't even know where does he come from. That does not mean you're not going to assist you, but it's going to take long. Please get a little bit knowledge before it goes far. Before it goes far, get a little bit understanding where this person coming from, what is his name, where is he residing, and what and what. Because for us to initiate the investigation process, when you don't even know the name, the same name, you only hear Jack. How many Jacks are here in Kimberley? It's a problem. But we are not saying we're not going to assist them. We're going to assist them, but it will take long. Now, we've got 13 investigators in the province, and they are stationed so strategically that each and every place can access them. Now, when you don't know the whereabouts of the respondent, that is where the investigation starts. And then at least must give the person the description. Why did you met? With whom was we going? What car was he driving? Why did he say he's employed? Or how did you meet? You must give him at least a direction to start. But at least if you know this person said he's Jack Matuka, he's driving taxis, he's from Botshabelo, he's staying in Two Town. You are making life very easy for the investigator. Maybe in a day or 2 days, we can be able to issue a subpoena. But if you don't have a clue where the person is, it's going to take obviously long. Again, as men, during the weekends, we talk these things. We talk these things. Sometimes we end up talking wrong things, especially in government departments, subs, and teachers. We have learned for the past 3, 4 years. They've got this thing that, oh, you're taking me for support, I'm going to resign. Even if you resign, we are still going to get that money. So it's not an option to resign. Because immediately that we are made aware that you are planning to resign or you have resigned, we interdict the pension fund. That money is going to freeze there. Some are lucky that the process will go quicker and then the money will be released into a bank account. But still, we are going to freeze the bank accounts. And normally when they resign, they change the addresses, they change the phone numbers. So it's difficult to get hold of them. Even if you can issue a subpoena, but it cannot be saved. But the nice part of it, when he or she goes to the bank and then the account is frozen, that person will ask from the bank, what happened here? No, it's the court. They will come running to court now because they want to access their money. That is when we start doing our calculations, the areas, future maintenance, and most of them, they come back with cheap money. From $1 million, you may end up getting 100,000 and you are no longer employed. So it's not a wise decision to do. Thank you.
Thank you very much, Ms. Mpaka. Just to add on the role of maintenance investigators. As I said, maintenance is an evolving discussion that we must always have. And I think we come a long way as maintenance functionaries, as government in general, that we want to create this system that is effective to address the issues of the vulnerable groups. The Department of Justice went further to appoint the maintenance investigators. And the maintenance investigators' role does not mean that they must always run after the maintenance defaulters or run after the people who are supposed to maintain. There are other tools that they can utilize, not necessarily to be running around. I mean, if we've evolved as maintenance that there are instances where you have to investigate while sitting in your office as a maintenance investigator. And we train them regularly to ensure that they are up to speed with the developments in terms of investigation of maintenance matters, especially when it comes to the issue of the whereabouts of the respondent or the people who are supposed to pay maintenance. So our investigators in the province are helpful to our complainants. We are quite aware that in the Northern Cape, we don't have enough of those investigators. I mean, that amount is not enough comparing to the amount of courts that we have. So you'll find that one investigator services different courts, maybe 4, 3 or courts that then that maintenance officer must be made available to. So integratedly as the system, we want to ensure that eventually we get to a space where we know that at least there is an amount of adequate in amount of investigators who can be able to assist our complainants. Remember, we are not advantaged in this province, and I must say, you cannot compare this province with Gauteng, where you have to visit courts. Missing Park you are going to visit 10 courts in a short period of maybe 3 hours. In Northern Cape, if I have to visit courts, if I have to go to Springbok, I have to drive 800 kilometers. There's no flight here to Springbok. If I have to go to other places of Calvinia, I don't want to talk even about those kilometers. So we are not advantaged in the province. And geographically, we are not advantaged, I must say. So in terms of performance, you cannot compare us with other provinces because of our geographical location and access to courts. So we are trying as much as possible as the system, integratedly so, to ensure that at least our maintenance officers are adequate. There are various engagements that are taking place. The Department of Justice knows very well for all these years, I've been fighting for appointment of maintenance officers and investigators in the province. We are at the space that at least we know that each court is catered for, despite the limitations and the geographical disadvantages that we have.
Thank you, Mr. Mulaudi, and also for giving me the heads up about the ratio of the Northern Cape as a province. Colleagues, you heard that if I want to go to Springbok, I have to drive 800 kilometers. So please don't be worried. I'll be there to come and educate you and train you whenever times comes. And when you have to drive here to from Kimberley to Uppington, how far is it, Mr. Molodi?
From Kimberley to Appington is 400 kilometers.
You heard that, colleagues. But I'll be visiting all the courts this year, and you'll get to know me and we'll interact. Mr. Matuka, now that you've also mentioned the consent orders, I know there's also a default order where a person does not come to court and then the court also grants a default order. So if the person has to receive maintenance, is there any system in place in terms of the justice system on how the person can receive maintenance, the applicant can receive maintenance? Or can the applicant say, no, I want to receive it in anyhow, maybe even in ShopRite, Checkers, or by hand? Or does the applicant has to go to court to receive that money for maintenance?
You know, previously people used to come to court to collect money. But as indicated before, the courts are not the banks. It's a risk to keep money at the courts. And it's tempting for officials as well. So we moved out of that system to say people, when you do new court orders, we call it direct payments. The money must go directly from the employer or from the respondent to the applicant's bank account. So we don't want money in our court system. But now there's that system that they call the Moja Pay. There are those files that we still need to convert to be direct orders. There are those that are still getting money from the court, but we don't want money in our court. Most of people are getting money directly into the banking details. Yes.
Yes, it's very important that we deal with the issue of payments of maintenance, because it's pointless if you have an order that's not direct you as to where this order must be paid to. So it's very important that we have to analyze this order to say who to pay, when to pay, what to pay. Very important for this order, this consent order to articulate that. But one thing that I want to talk about when it comes to the issue of the province, when it comes to payment, we took a decision that we need queueless courts in this province. Gone are those days where our people will go to court, will stay the entire day waiting for a list to be forwarded. By a certain mind, the list is not forwarded. One official is called, and then they are not sending the list. We passed that stage. And I think as the country, we must move along those lines to ensure that we've got queueless courts, especially when it comes to maintenance, because I think our people have suffered enough when it comes to maintenance processes. This act, even though we still have to go for amendment, but it caters for a lot of things that we can do better in our system. So in this province, we took a decision that queueless courts, direct payment. Meaning, what I normally request from Mr. Matuka is to say that, where are the Section 19 orders? Where are the Section 19? Because we need to ensure that we amend these orders to cater for direct payment. And our maintenance officers are measured at that level to say, each court, how many orders have you made in terms of Section 19 to convert this order to direct payment? Because of, we have to push for queueless court. We have to ensure that our beneficiaries are not being frustrated by the system where they have to spend the entire day in court while waiting. When the respondent receives payment, salary on the 25th, the applicant must receive the maintenance payment on the same day. That's why it's important for our maintenance officers that for the first order, you apply for the amount to be put in the bank account of the complainant. Let's make it easy. Let's not do it through sections and other things. We need to ensure that that application is made and it's of assistance to some of the respondents, that money will automatically go there in as much as you pay lawyers who have an order against the respondent, you can as well pay the maintenance beneficiary right there. So it's important that the employers are also part of our system to ensure that we educate the employers well when it comes to obligation on maintenance. Thank you.
Thank you, Mr. Mlaudi. Now that there's a maintenance order in place and the person defaults, how does the system works?
Very important that we need to talk about enforcement of maintenance orders. As I said, it's pointless to have an order that is not effective, that is not going to be of assistance to a person that is supposed to benefit from this order. The applicant will approach the court to indicate that according to this order, let's say, for instance, direct payment was not done during that first order. Direct payment was not done, the respondent is not paying because of, the respondent must pay the money into the bank account of the complainant, but the money is not coming in. And I want to dispel this last myth that I spoke about, that we need to ensure that this system caters for our people. Our people goes to court, they are being told that you must wait for 3 months. I must dispel that myth. It's wrong. The law does not say that. If the maintenance payment is unsatisfied for a period of 10 days, the applicant must approach the court with what we call the complaint form. The clerks are there to assist. And I want to emphasize on the role of the clerks. Our community members, some of our community members cannot read and write. That's where the Department of Justice comes in now in terms of the involvement of the clerks in the maintenance value chain as to how are they going to assist our people. You cannot just give a person a complaint form and say that fill this form. The complainant does not know how to read, how to write. And some of our people, they've got some disabilities. Obviously, you are going to have some challenges. It's important that the maintenance clerks are made aware that you need to assist the applicants, the complainants, to ensure that they get access to the system. So the complainant will approach the court, we call it a complaint form. Complaint form will be filled to say that this amount of money was supposed to be paid on this day. It's very comprehensive, that form, in terms of covering all the bases when it comes to defaulting on maintenance. And then the matter will go to the maintenance officer. The maintenance officer will do what is required in terms of the law. We do have enforcement mechanism in Maintenance Act, and which are very effective, especially the civil ones. I'll talk about the issue of prosecution as a last resort. But I want to emphasize that when we train prosecutors, we ensure that the prosecutors are trained in civil attachment, because it's an easy process to recover money for maintenance. Because remember, in civil proceedings, you stand and you rise by your papers. So basically, what we have to do is to ensure that our prosecutors, our maintenance officers are effectively utilizing civil procedure, because it's important that you rise and fall with those papers, because it's important that you articulate well what is the position in terms of what you intend to achieve as a maintenance officer or as a maintenance prosecutor in that court. So we've got attachment of emolument, where we can attach the salary of the person to maintain. That is in terms of Section 26, Section 28. We do have what we call attachment of property. When we attach property, we start with the movable first before we go to immovable properties. And we've got what we call an attachment of debt. I'll give you an example as to how important attachment of debt is. I'm a medical doctor. I just performed a serious medical procedure. I owe maintenance to a tune of 60,000. The complainant approaches me as the maintenance officer. Through investigation, I became aware that a certain medical scheme is going to pay the respondent a certain amount of money. Through civil procedure, you can always attach this amount of money. Instead of going to the respondent, who is the father, who does not maintain, that money can go to the applicant or the complainant in this setup. So it's important that the civil attachment are effectively utilized. And then we do have another form of enforcement of maintenance order, which is the prosecution. That's where prosecutors comes in now. Prosecutors will be able to prosecute maintenance defaulters. But remember, as I indicated, it's very important that we get to these orders, we get the right order from the beginning. Because of if there was a direct payment, we are not going to experience any challenges, because of the money will be coming straight from the employer to the applicant. Now that we don't have at this point in time, we have to resort on civil attachment and also on prosecution. Our prosecutors are trained how to prosecute maintenance matters. They are trained how to go about in terms of prosecution of those matters. They are quite aware that at the end of the day, when civil attachment, there's an opportunity for civil attachment, you should be able to explore that opportunity and recover money as quickly as possible. Our investigators are well trained in terms of tracing where money is. They are well trained in terms of the investigative tools as to how to get this money. We can also always go to the extent of freezing the bank accounts if the money is available there to attach this amount of money to ensure that maintenance is realized. This is how far we went in terms of ensuring that maintenance is recovered as quickly as possible. We are not saying that people must not be prosecuted, but there are instances where you know very well that this person is gainfully employed at the Department of Social Development. We know very well that on monthly basis is getting an amount of money that is coming as a salary. We need to attach this salary. And the beauty about it is the moment you attach the salary of a person, you know very well that you are not going to deal with this person going forward when it comes to maintenance default. Because you are going to attach the amount that the person owes in terms of the application of the complainant, and then you are going to attach the monthly amount. Meaning you are taking responsibility from this person. You are transferring to the employer to say that employer, you deduct this amount of money for maintenance arrears, and you deduct this amount of money for what? For the maintenance that this person is supposed to pay according to this order. So you are no longer going to deal with that particular person when it comes to default, because when this order is effected, when the complainant comes and say, I now make an application for increment, inquiry is held, the amount of that amount is increased because the arrears by then will be paid off. And then the complainant comes at a later stage and say that now I want to apply for, because my needs now warrants me to apply for substitution. I want to increase this amount of money. Then the amount will be increased. The order will be sent to the employer if they agree that now we are increasing the amount from 1.5 or from 3,000 to 4,000. The amount will be, the order will be sent to the employer. The employer will now deduct this amount of money going forward. So the issue of default, continuous default is dealt with because the law allows us to do that. So it's very important that we get to civil attachment. We educate our community members that assistance is there in courts. Despite prosecution, there are other tools that can be utilized to ensure that maintenance is effectively paid. And then we deal with this issue of feminization of poverty that is happening in our country.
Thank you, Mr. Malaudi. Does that mean, Mr. Malaudi, that when a person is gainfully employed or no longer employed, but then maybe he's receiving maybe money in the insurance policies or retirement policies, can you also attach that money from the policies as you can also attach monies in the banks?
Now, what we normally do is it's very important for a comprehensive investigation, what we call a financial investigation. You are not only limited to something that you see. It's very important that we have those courageous investigators who will be able to go beyond and investigate the income of a particular person. It's very easy to deal with people who are gainfully employed, where you know that there's one source of income, which is a salary. But now it's very important to investigate. It's important to investigate all this web that the people normally create. And what we see in this country is when people hide money now in trust. So what we have to do in terms of investigation, obviously we have to ensure that we know who are the trustees in this account, because in this trust, because we'll find that even the respondent, the person who's supposed to pay maintenance, is one of the trustees in this. So there is a way of hiding money now behind the trust. So we need to pierce this corporate veil and understand who are behind this trust and why the complainant, the respondent is not paying amount. Because the person is going to say, I'm not working, I'm not gainfully employed, only to find that the person is getting a lot of money when it comes to trust because of, it's now a trustee there, it's a trustee there. The complainant does not know. So thorough investigation is very important. And one of the things that we have to do in terms of development of the law is to equip investigators extensively when it comes to investigation of trust funds. Because people are now hiding money behind the trust. They'll say it's a family trust, it cannot be touched, only to find that the respondent is a trustee here, generating money. So investigation is important, not only limited to policies, not only limited to other things, but attachment should be investigated extensively so as we can touch all the places where we think money can be entrusted with. Very important to investigate all this financial institution. Our investigators must ensure that as they issue Section 8 subpoenas to this bank, you cover comprehensively what you need from a certain bank or a certain institution of finance to ensure that we investigate this so as our complainants can get what is due to them in terms of the law.
Just a follow-up question, Mr. Malaudi. You touched on prosecution and you said you'll elaborate further. Now, after all the civil enforcement has been exhausted and there's no money that you can get in salaries, debt, and warrant of execution, how does the prosecution deal with Section 31 matters?
Everything that has to do with the prosecution of a person boils down to investigation. We need to ensure that we investigate these matters thoroughly as I indicated, that there's an issue of trust and where people hide money. We need to ensure that as a prosecutor, when you decide to enroll this matter, your investigation is completed. And I want to emphasize this. We need to ensure that after everything has been done in terms of your reports, the maintenance investigator went to these places, and then your report will tell you as to how you are going to deal with that particular matter, whether you are going to enroll it or not. But what we discouraged as NPA in terms of our prosecution of matters, we request our prosecutors not to convert the criminal proceedings into a maintenance inquiry unnecessary and sometimes without even authorization from the senior public prosecutor. So you are going to convert precisely because of you didn't get your ducks on a row in terms of investigation. Investigate the matter, ensure that everything is in place in terms of you prosecuting. But I want to ensure one thing. I want to indicate to our community members that there's one thing that we call you cannot draw blood out of stone. If there is no income, if investigation revealed that absolutely there's nothing that the respondent has in terms of assets, nothing to attach, definitely your report will be able to articulate that the contentious and complex matters are dealt with, guidance is given to prosecutors, and training is provided to ensure that we successfully prosecute this. But I normally say that if there is civil attachment to explore, why not? Attach enough as you can in terms of the law. So civil attachment is an easy process, even to get to there. It's important that we enforce that our prosecutors understand civil attachment. It's a process that is going to make easy for us to realize this objective of the maintenance.
Thank you, Mr. Malaudi. Just a follow-up question again. What happens when, in our country, in South Africa, we know there are challenges of people losing their employment, their retrenchment, some resign from their work, and then there's no money wherein he can pay maintenance, and he was paying maintenance, and he does not even come to court and say, approach maintenance officer to say, I have a maintenance order against me, and but then I'm not gainfully employed. How do you deal with a situation wherein the applicant comes and then complains that she's no longer receiving maintenance, and she does not why is she not receiving maintenance?
Thank you very much. The beauty about our law when it comes to maintenance, the monetary jurisdiction in maintenance courts. In maintenance court, we can attach millions. The law allows us to do that. But remember, when I talk about the law, I talk about case law, because remember, this is not legislated. We don't have future maintenance. We are talking about future maintenance. We don't have future maintenance in our law. That's why now we are moving forward in terms of South African Law Reform Commission to put future maintenance in our law, because we are dealing with future maintenance in terms of case law. And this development came because of the challenges that we faced in the system. This matter has been processed in court for a long period of time. But it's important to articulate where we come from as the system, so as our viewers can understand. A person who was ordered to pay maintenance resigned. Now I'm going to go back to the original order now, because the original order does not indicate that the employer must take this money and give it to the complainant. We are not going to be made aware, because the employer is not aware, because of the person is not paying through the employer, right? The person is paying on his own and on his or her own, and at the end of the day, to the bank account of the complainant. But now, how are you going to know as the court that this person has left employment? Very important that we have this kind of orders where the employer pays the money, because the employer will notify the court to say that don't be hopeful, this person has resigned for various reasons, because they don't stipulate as to why this person resigned. And we know very well that, as Mr. Matugas indicates, some people resign because there's a maintenance obligation against the person. So the employer will not notify the court. The complainant will approach the court through luck, maybe to say that I know that this person has resigned, or this person is going on pension. There is a maintenance order granted by this court. What is going to happen going forward? More awareness campaign to be made when it comes to future maintenance, because in this province, a lot of future maintenance has been done because of most of the companies, especially mining companies, since the BS left. A lot of maintenance orders have been generated here for future maintenance. We need to articulate where we come from with future maintenance, because of it's an integrated approach because of the challenges that we faced, and the courts developed what we have to deal with. And then the complainant will approach the court and say, the respondent is going to go on pension, or the respondent has resigned, but I don't know why he resigned or she resigned. And obviously, it's something that investigation must be done as quick as possible. It's something that is going to trigger investigation to say, we know very well that this person was paid maintenance here, and then the employer was not responsible. But now we have to rope in now the employer to say that we need future needs of this. Because remember, we don't know how and when is the respondent going to get another employment opportunity because of the challenges that we have in the country. So the maintenance investigator, the maintenance officer must work together to ensure that we get to a space where we know that we've got a letter now which confirms that the person has resigned, and we know how much is due to this person. How are you going to ensure that the future needs of the child are catered for, or the future needs of the person to be maintained are catered for? So it's very important that we deal with that aspect, that we normally focus on the child, because we are dealing with child maintenance. What we do now, the maintenance officer will make an application now before the court for future maintenance. And very important for the maintenance officer to aware the issue of urgency. This matter is now urgent, because at the end of the day, if we don't do that in time, the money will be depleted, and we'll sit with a problem where we know that we are not going to attach because the money has been depleted. So it's important that investigators and officers, prosecutors work together, interdict the bank account. If you are late to interdict the pension fund, interdict the bank account and ensure that at the end of the day, there is money that is going to be received. And what we normally do is we cite the Master of the High Court. Very important, because the Master of the High Court is the upper guardian of all South African children. So the Master of the High Court will be cited, the respondent will be cited. Obviously, if there is amount of money that is already paid in a certain account, we'll deal with that aspect. But now, in this process, obviously the maintenance officer, the maintenance investigator must investigate enough to ensure that we know that what is due to the applicant, to the respondent. Then the money, if let's say there is an amount that the respondent owed at a certain period of time, it can be dealt with in that particular process, where maintenance arrears are going to be deducted and given to the complainant, because it's that amount that the complainant was due to get, but now the respondent did not pay in time. Arrears will be resolved at that level. But now we are talking about the child here. We cannot give that amount, the huge amount of future maintenance to the complainant, because at some point we had issues where people bought RDP houses with this amount and all those things. So we said, Master, can you come in and assist us and ensure that this money is kept in your account, interest-bearing account, and where the complainant will access this amount of money according to the court order that was issued by it on this monthly basis. So one person can ask, what is happening with this amount of money if, let's say, the child reaches a certain age? Those are the processes that are going to be run by the maintenance officer to say, at some point, the child now is gainfully employed, it's an adult now. Obviously, there's a certain remainder of the amount that is left there. Those are the amounts that are going to be dealt with by the maintenance officer as to how you are going to do that this amount reaches the respondent. But future maintenance remains a challenge because of the fact that if you don't investigate in time, you are not going to get anything to recover for future maintenance. We encourage our communities, as they get this information, to approach the court as quickly as possible. Because remember, this amount of money is about the upkeep of a child, because we don't know as to when is the respondent or the person to pay maintenance going to get an opportunity for employment going forward.
Mr. Matuka, just want you to tell the viewers, now we have the bank accounts that have been interdicted, and now the respondent comes to court and say, okay, I'm here, you called me, my account has been interdicted, I've got no transport, and an inquiry has been held. How do you assist in such a case? And says that maybe he wants money for transport. Is justice government going to help in that case or not?
Let me start by these people that are hiding monies. Remember, the only tool that we had for our maintenance investigators previously was the ITC. But the department entered into a memorandum of understanding with TransUnion. They've got various products, although they're expensive. That will be for those tricky cases. So with TransUnion products, there's no way that we can hide money in the trust account or companies or wherever where we won't be able to trace. We are still going to trace that money. Now, when it comes to the issue of respondents of which their bank accounts have been freezed, remember, the respondents used to pay money to the applicant directly or to the court, but now decided to resign and keep the money. So the relationship between the department and the respondent, it ceased by that time. So there's no trust anymore between the two parties. So immediately the respondent is made aware that the account has been frozen. The first step is to go to the court. When you arrive at the court, your file will be located. You will have to make the calculation in terms of areas, and if there's a future maintenance application involved, then we do that. Then we deduct that whole money from the bank. Or the court order will be crafted in such a way that the areas and future maintenance are covered. Certain portion to be directed to the master of the High Court, like Advocate Muller indicated, and then the areas to directly to the applicant. Then the remaining, if there will be something left, will go to the respondent. Yes.
Tata Matuka, Mr. Mulaudi. In South Africa, we're facing this high rate of immigration, wherein people move abroad, and there is no way that you can trace them. How can you, the applicant of maintenance, be assisted in that case where a person is not in South Africa but abroad, and the mother and the child are here in South Africa and they want to apply for maintenance? Is there a system in a maintenance where this applicant can be assisted?
Thank you very much. What we are talking about is what we call reciprocal enforcement of maintenance. What we termed it foreign maintenance. It's a frustrating process, I must say. It's a frustrating process in the sense that it is not even in the act. We deal with other legislation. African want there's a legislation that deals with African countries and the other countries as well. We have what we call proclaimed countries, where I spoke about the issue of international instruments that South Africa is the signatory to. We utilize these instruments to ensure that we enforce maintenance orders in other countries as well. So when we have what we call a proclaimed countries, it becomes easy because of now there are some arrangement between South Africa and that country to deal with maintenance issues, because in all fairness, some countries don't treat maintenance as a serious issue like we do in this country. So it becomes a challenge where that country does not regard your documents as urgent as they are supposed to be. So it's important that we have this proclaimed country, but it's not the end of it if we say that no, the country is not proclaimed, we don't have a treaty with this country in terms of enforcement of orders. We do have diplomatic relations where we get in our DERCO and other departments to assist us to ensure that we get that particular person outside, who's outside the country. So our complainants, our maintenance beneficiaries can approach the court. And then that will be dealt with in terms of the processes that are happening in court. But remember, as the courts, we don't have continuous reports when it comes to the effectiveness of what the court processes have been sent to that particular country. So meaning, what we do, we finalize everything in terms of the inquiries. Information is going to be sent to a central authority. We call it central authority, which is the Department of Justice, where Mr. Matuga is working, where there's a component that deals, we call it international relations. They deal with this aspect. If the matter is done in Kimberley Court, obviously, the processes will be done in Kimberley Court and information will be sent to DERCO, and DERCO will make the necessary connection with the country where that person is. But I must say to our community members, it's not an easy process. It takes time. We don't want to give false hope to our complainant to say that we are going to complete it in the period of 6 months or so. It takes a long time because of, as the court in that specific area where the complainant is, we don't have powers because of we cannot make follow-ups. We rely on the Department of Justice as the central authority to liaise with that particular country to ensure that these documents are received. It's a long process. It's back and forth that we have to deal with. But we are not saying to our complainants, don't approach the court. Approach the court. Let's assist you. Let's deal with this foreign maintenance together to ensure that the obligation of maintenance is realized.
Thank you, Ntate Molaudi. Our viewers, we are nearly at the end of our presentation. We've got 2 questions from our viewers, Ntate Molaudi. One question from our viewer says, with regard to attachment or resignation for retirement benefits, do you only attach arrears or also future maintenance, or both?
We do both. Because as I said, we don't know when is the respondent going to be gainfully employed. I indicated that if there were arrears, we attach the arrears. We ensure that the arrears goes to the bank account of the complainant when the order is done by the court. The court issues an order, then the court will direct that this amount of money, let's say 40,000 or so, will go to the respondent. I mean, to the applicant, the complainant, because of, by then maybe you'll find that there are amount of arrears and then the respondent was not paying. The complainant has some serious challenges in terms of court processes. And then when this person resigns, when the respondent resigns, there is an amount that is outstanding that was not attached. So if there are arrears, we can attach those arrears and then we can deal with the issue of the master now, where we attach this amount of money for the future benefits of the child, and then the master will keep it there. So we do both to address this issue.
One other question coming from the viewers is that most of the applicants would come to maintenance and apply for maintenance, but then refuse access to the fathers to see the kids. Is it in the best interest of the child not to see their fathers, or is there any system in place in the justice system where we can help the father to see their kids?
Ms. Mpaga, is not in the best interest of the child. And we are getting this kind of cases where there is a children court order that the father of the child must be able to access the child and spend some time with the child. And then you'll find that the mother does not comply with the court order. And it's unfortunate at this point. But the system caters for this because integratedly, that's why integration is very important, that we are not specialists in the maintenance functionary when it comes to that. We enlist the services of the family advocate to investigate this aspect. That's why the maintenance officer can refer to the family advocate to investigate this aspect in relation to the fact that now during inquiry, normally it comes during inquiry, the inquiry where the maintenance, the person who's supposed to pay maintenance says that you want me to pay maintenance, but I cannot see I don't have access to my child. So it's very important that we do those referrals to the specialist, because the family advocate is responsible for the upkeep of the child when it comes to the best interest of that particular child. The maintenance officer can refer these matters can be investigated. And then obviously when it gets to that processes, you'll find that there is a parental plan that is going to be made. If that parental plan is not complied with, obviously the matter will go to the children's court where there can be an order that the father must be able to access this child and spend some time with this child. If the complainant does not do that, obviously we are going to go to a stage where we now have to charge for contempt of court, because it's a court order now that this must happen. But we discourage our community members to do that. It is not in the best interest of the child, as enshrined in our Constitution, in our Children's Act, and in the Maintenance Act, and our international instruments, that we have to ensure that whatever we deal with when it comes to a child, the best interests of that particular child are paramount. And it's important that as we move along to ensure that this ecosystem of maintenance is effective, we must move for our communities to understand where we come from in terms of the best interest of the child.
Maybe just when I started, I said we are also responsible for the specialized courts in the country or in the region, which will include your family courts, which is family courts. It's your what you call children's court, your maintenance. Now there are those aspects that has to be dealt with in the children's court. Issues of custody, parental plan, those has to be done in the children's court, and normally have been referred to officer or family advocate. When it comes to maintenance, we're only dealing with the upbringing of the child's needs. But like Advocate Mulad indicated, we discourage that kind of behavior. But for personal reasons, some couples, when things turn sour, they make use of the child as a middle person now. But we don't have control over that. I remember there's a recent Western Cape judgment where the judge said the court can enforce maintenance, but we cannot enforce a relationship between the child and the father or the parties. But maintenance, we can enforce it. But the relationship, unfortunately, the court cannot do that. Thank you.
There's another question from our viewers who wants to know that there's a reluctancy in our police officers to deal with maintenance warrants. Can they assist in saving the warrants on the respondents, the police officers? We know we have our maintenance investigators, but how do you deal in the situation where the police officers are reluctant? Can they also serve warrants of arrest on the respondents?
Very important. Ms. Mpaga, what we encourage, and it's what our organization NPA is driving towards, to say we need to have this maintenance forum. When we have a maintenance forum, all those maintenance related challenge will be resolved at that level. You can imagine if you have a maintenance forum where you have all the court managers, where you have the sheriff, where you have the investigators, where you have police officers. So it's important that we get everyone participating in this criminal justice system. Meaning, if let's say there is a warrant of arrest, and sometimes we get frustrations where investigators cannot execute this warrant. It's important that we get police officers to execute this warrant. If they have to arrest the person and the person must appear in court, it's important that we do that. But it becomes difficult when we don't have police in your maintenance forum. So we encourage that our police officers must be able to assist us. In our courts, we do have those court orderlies, but they cannot execute those warrants because they are not working outside, they are in court. So it's important that we have a specific, like in other courts, we do have a specific police officer who deals with warrant of arrest. So our maintenance officer are encouraged to have a specific person who specifically deals with warrant, and they can be able to assist the maintenance courts. Because of through linkages and all these referral processes, our police officers should be able to assist us in terms of executing the warrant of arrest as they are issued in the maintenance court. So we encourage our maintenance officers, let's have this forum. This forum must be effective to deal with all these maintenance bottlenecks. We won't have issues of warrants if we have a maintenance forum that is effective, that ensure that everyone is accountable in terms of the maintenance value chain.
Maybe just to add, when it comes to the execution of warrants of arrest, it's not only the challenge in the Northern Cape, it's a national crisis, especially when the warrants are aimed at or is targeted one of the members of SAPS. It normally takes long, but now it differs from one court to another. But here in the province, if there's an issue with an execution of warrant of arrest, the court manager will escalate it to us and then we'll take it to the legal unit of SAPS. In that way, we normally succeed. Even if it's interprovincial, whether it's Rustenburg or Northwest or Gauteng, that is how we deal with it currently.
There's one question again from the viewers who wants to know that when they're at the children's court and they're dealing with parental plan and also contacts, when the issue of maintenance arises, can the court grant maintenance in the children's court? And while we are at children's court, I just want you also to add on the question of domestic violence, whether when the parties are at domestic violence, can the court also order a maintenance order at the domestic violence?
Yes, we definitely have to ensure that we don't read Maintenance Act in isolation. And that's why you get to other things, because of you don't read Maintenance Act in isolation. Our Domestic Violence Act, as amended, provide for monetary relief, right? Where the court will issue emergency monetary relief. And where the matter was referred to the family advocate, you'll find that we have to ensure that we differentiate our roles, because of the maintenance officer will end somewhere, right? And then obviously when you refer this matter, by then you are dealing with maintenance already, right? You are dealing with maintenance. Maybe you are going to refer this matter at a later stage, the issue of custody at a later stage. But by then you are dealing with maintenance. And chances are you are going to have an order, right? You won't have problems when it comes to maintenance. But let's say, for instance, now there is no order. You referred this matter. You didn't finalize the issue of the order in the maintenance court. Obviously, now there's going to be a challenge if we have to take it further, because we still are dealing with this issue of maintenance. It's important that we finalize this aspect. So when this matter goes to other courts, we know that the purpose of the application was realized. There is an order already. When it goes that side, obviously there'll be a report that indicates that it's already an order of maintenance. But it's important that referrals must be done the right way. When it gets to the family advocate, at least all these issues are being dealt with. And the family advocate will take it from a point where the maintenance court does not, deal with that, because we cannot deal with access in the maintenance court. They are the professionals. They deal with that. When it goes to children's court, the court will deal with this aspect. But our focus will be in maintenance. And then the application must be entertained there. It must be dealt with. The complainant must be assisted at that point in time before he can even think of what referral, because of now the application must be dealt with. The complainant is here. The respondent is here. This issue is raised. Let it go for referral that it's supposed to go for.
Thank you, our presenters. We've come to the end of our presentation, but in closing, I'll just like you to tell the viewers about the challenges that you get in Northern Cape while dealing with the maintenance issues, just in brief, so that I'm also new in the Northern Cape. I'll also know how to deal with the maintenance issues in the Northern Cape and the challenges that you are facing here.
Maybe let me first just comment on the issues that became regarding the EV and maintenance. It is true that you cannot read Maintenance Act and Domestic Violence in isolation, including your Children's Act. Remember, when it comes to domestic violence, we are saying there are three forms of abuse: your physical abuse, your emotional abuse, and economic abuse. Economic is where maintenance comes in, although it's still domestic violence. But however, like indicated, the court will only grant an interim relief. In other words, they're going to say Jack must pay 1,000 rand for 4 months, because they know the process of maintenance more can be 4 or 5 months or 6 months. But they will still refer you to the maintenance court, to the correct tribunal, to say Much as we're handling this matter, but the right tribunal to address the issue of maintenance is maintenance court. The domestic violence amendments as well, they make provision for the court at any time when they realize there's a need for referral to the office of the female advocate. They do it. The children's court as well. So we are not dealing with issues in isolation. So what is relevant to which court at the time?
Thank you very much. On the issue of challenges, I'll just talk to two issues. Shortage of maintenance officers and investigators in the province. Engagement are taking place. We know very well that we still have to fill the vacancy in Datlas. We still have to fill the vacancy in Appington, the vacancy in Kgaleshiwe. So our people, so as they can be able to access that. We impress on justice to appoint and ensure that integratedly we move along in terms of filling those posts. And secondly, the issue of abuse of the system in the province must be dealt with harshly. We need to encourage our communities to do what is right, to ensure that every person who's before the court has legal obligation to do that. And thirdly, is the issue of talking on the issue of attachment. We don't have a ring-fenced amount where we attach a property of a person in the Department of Justice, where we can say that if the complainant successfully managed to get the court order in terms of attachment, the sheriff is going to charge that particular complainant. You'll find that the value that the sheriff charges in terms of storage fees is almost the same amount that the complainant, that the respondent owes, which is due to the complainant. We encourage our maintenance officer to ensure that those maintenance the fora are effective. We've got the relevant people in terms of the maintenance value chain, and they participate effectively and ensure that the complainant are assisted, despite the fact that we don't have a reinforced amount in terms of enforcement when we attach property of the respondent who did not pay maintenance. So going forward, Ms. Mpaka will be responsible for maintenance matters in the province. She's our newly appointed senior maintenance prosecutor. It does not mean that I'm out of maintenance. It's still my responsibility as the provincial manager of SOCA unit to ensure that maintenance matters are dealt with. We are going to support Ms. Mpaka as the Department of Justice and as NPA in the DPP's office. Thank you very much.
Thank you, our viewers, for taking your time today and listening to us. The webinar today thought it's very fruitful and you have learned a lot. I'll be there every step of the way. Our offices are open for everyone. If you have a maintenance issue and if you have a complaint at the courts, there's a court manager in our offices. Mr. Matuk, our legal administrative officer, is there. And also our doors are also open as senior maintenance province at all the provinces in the Northern Cape. And in closure, if you have any information about this topic today, you can also contact our communications at npa.gov.za. You'll also have this topic on Twitter. You can also get it on Facebook, and also you'll also get it on YouTube at any time. Thank you.